it's important to understand the nature of it, almost as important as it is to understand the substantive law involved in the various states. It goes all the way back to Germany in the 19th century with the chancellor. Back then, Wisconsin was the first state to enact workers' compensation legislation in 1911. What was happening was employers in the early 20th century were finding that their employees were able to sue them whenever they were injured on the job, and this was quite frequent. Now, those employers had common law defenses like assumption of the risk, fellow servant doctrine, contributory negligence, but still they were having to defend a lot of lawsuits for people who were out of work and had no other means of supporting themselves. So society decided that it might be a good idea if we would take care of workers' disability, injuries, medical bills, etc., via a program that would be paid for by the employer, who they figured was able to bear that burden a little bit better than the employee. And workers' compensation was born, but it was born out of an agreement, and the agreement was the employee would get unlimited. Well, originally it wasn't unlimited, but in some states, unlimited medical to start with, lost wage benefits. Hang on, I had to click record, otherwise Jamie was going to yell at me. Lost wage benefits and things of that nature. And in exchange, the employer could not be sued by the employee. And the employer or the workers' compensation carrier, and if you can look at the history of a lot of the major U.S. insurance companies, they all had their roots in the area between 1911 and 1920. And the reason for this was an incredible opportunity for indemnity workers' compensation insurance, and also the automobile around this time began to be mass-produced, resulting in auto accidents and a very, very plentiful source of work for trial lawyers. All of this history has gone into in depth in the two books I'm referring to, and we'll have a slide on later. And by the way, I'm not peddling the books because, and I say this just because I don't like to be thought of that way. We make almost nothing on the books. Authors these days, publishing is a pitiful industry right now. And the cost of printing and all that, the publisher takes home the lion's share of everything. But it is important, and it's a great resource, both of those books. So most states followed in 1913 or thereafter, and of course I've explained the purpose of workers' compensation. Now, work comp subro, and most states passed work comp subrogation laws around 1919 to 1930, allowed the carrier to recover monies paid to or on behalf of an injured employee when a third party was responsible. Work comp subrogation is almost entirely dependent on state statutory law. This is despite the fact that work comp policies have subrogation language in them, and you can subrogate via that subrogation language, via contractual subrogation. But the statutes usually are a lot stronger when it comes to your rights as a workers' compensation carrier. And of course, the purpose of subrogation to prevent the double recovery and place the ultimate burden on the tortfeasor rather than on you or your insured is a very important purpose, but unfortunately one that's been forgotten over the years as trial lawyers' influence spreads and justices and legislators began passing laws that made it possible to bring in employers for contribution or require an employee to be quote-unquote made whole before the carrier could get its money back. So over the years we've sort of forgotten about our basic compact, the one that started workers' compensation to begin with. It's a very interesting history and one that actually will help you understand the law as you work within it, but we don't have time to get into it in a whole lot of detail. There are three main building blocks for anyone involved in workers' compensation subrogation, and it's my understanding that today we're going to be flying over at the speed of light 10 states: Texas, Illinois, Missouri, Mississippi, Arkansas, Wisconsin, Oklahoma, Nebraska, Iowa, and Kansas. And it's one of the most important, if not the most important aspect of workers' compensation subrogation is early recognition of subrogation. Because if you don't recognize that there's potential third-party liability, nothing else matters. The file is closed, there's no recovery, no notice letters are sent out, no products are preserved, no subrogation counsel is engaged, and there is no check coming in the mail somewhere down the road to represent a subrogation recovery. So we have a 2-hour webinar that focuses on just this slide alone. And while that may seem like overkill, we have an entire webinar on recognizing third-party liability, prompt investigation of workers' compensation subrogation, subrogation investigation techniques, and aggressive and cost-effective strategies used. That's a 2-hour webinar on just this slide alone, just to give you some idea of how much material there is and how much educational opportunity there is in workers' compensation subrogation. So for every claim, we want to answer these questions. What are your subrogation rights? Which third parties can be sued? How is recovery allocated? Are attorney's fees or costs owed to the plaintiff's attorney or to the employee? And do we get a future credit? Unless you know the answers to these questions, you will be recovering less, if anything, than the maximum that you are entitled to and could recover. And subrogation represents one of the few areas where money actually comes in to the insurance company as opposed to going out. So it is certainly a worthwhile area in which to invest time, money, and education. And hopefully that's what we're doing to some extent today. But we'll be going over briefly these 5 questions with regard to the 10 states that you've asked me to go over with you. But as I've intimated, we're going to have to go over those states in somewhat cursory of a fashion, even to the point where the slides that you'll be seeing for each state look pretty similar without a whole lot of meat to them, because it's not possible. I would have 800 slides if I were to try and pin down in a bullet point for a PowerPoint slide each of the significant items that probably should be discussed for every state. But we will go over the fundamentals for every state. And once you understand those, questions will rise in your mind as you handle files, which will lead to other questions, which will in turn lead to the other materials that we probably won't have time to go over for each state. The 3 L's of successful work comp subrogation investigation are liability. You have to understand tort liability, which is why a 2-hour seminar on recognizing subrogation is really even pretty tight to get in a basic overview of a first-year law school torts class, negligence, product liability, strict liability, automobile liability, things like that. But you need to understand tort liability. It's easy when we're talking about an intersection collision and one car hitting another, but it's not so easy when you are the car which is doing the rear-ending and you still want to subrogate. And that can be done under a number of facts. And I know that sounds rather provocative, but it's important to understand that there are subrogation opportunities even with bad facts. You have to understand the law. We're going to be going over this briefly today in terms of both auto and work comp for the 10 states that you've asked me to discuss. But as you see, we're going to be flying at light speed. And then labor. There is no shortcut to successful subrogation. You have to take the time and use the tools that you have in order to uncover third-party liability, preserve evidence, put the appropriate parties on notice within the appropriate time periods, engaging experts, doing investigation, getting reports, working with subrogation counsel, and retaining subrogation counsel. And I don't say this because we are a subrogation law firm, although it's going to sound like I am. But the truth is, it's very difficult to get by and successfully subrogate except in smaller auto subrogation MedPay cases where you may be able to ARB or you send out demand letters and you work with plaintiff's counsel. But subrogation counsel is often an important part of the subrogation puzzle. And it's to be remembered that subrogation is an investment that does pay dividends. So I'm going to be going in the order that I listed the states earlier, and we'll be covering workers' compensation for all 10 states just briefly. And then we will be covering automobile insurance subrogation for all 10 states briefly, and then we'll have a few summary slides. And that will be the conclusion of our 56 minutes that we have left. If I have to go over a little bit, I will, but like I said, it'll be tight to get everything in. Workers' compensation subrogation in Texas. Texas used to be the best state in which to subrogate work comp. They had the best statute. They allow a first money right of recovery. And in 1987, 1989, tort reform hit, and employer negligence began to play a role. And it sort of fell down to about number 9 or 10 on the list. Currently, Wisconsin is the best state to subrogate work comp, and it has the most favorable statute, allows you to obtain 100% recovery without attorney's fees, and has many other favorable features. Arizona, also a very favorable state. California, believe it or not, is a very tricky state, but can be a very successful state to subrogate in. But Texas is certainly in the top 10. And in Texas, when we talk about, remember the 5 things that we need to know for each state. Subrogation rights. In Texas, the workers' compensation carrier can file its own suit. It can do it any time within the 2-year statute of limitations. It can file its own suit before the employee does. There's no need to give notice. You can simply file your suit, sue as Triangle Insurance Company as subrogee of Joe employee, and you're off to the races. It's very favorable. It allows you to basically try the plaintiff's case and recover all damages that he would have recovered, reimbursing yourself your lien, and any excess that's left over go to the employee as a future credit. When the carrier files its own third-party action in Texas, the carrier has the burden to prove both the reasonableness and necessity of medical expenses it has paid to the worker, not simply that it has paid them, but if it intervenes into an existing third-party action, all you have to prove is the amount of your lien. There's a whole subject that we could get into in terms of what money can you recover. Just your indemnity and medical payments, funeral, what about nurse case management fees, fee management, claims handling fees. Every state is different, and there's an article on our website. And by the way, on our website, there's a feature called Subrogation Questions. If you have any questions, and I'm sure you will, on any of these issues in any of the states we cover or any state in which you subrogate, you can simply send us a question via that website, and it usually is answered within 24 hours. Now understand that while we're covering 10 states here, if you're handling subrogation in Texas, it doesn't mean that you're not going to get issues relating to New Mexico, because if a New Mexico employee claims benefits, if a Texas employee travels to New Mexico and obtains New Mexico benefits, you might have a case in Texas in which New Mexico benefits are being paid, and New Mexico subrogation law may be applicable, but we won't be getting into conflicts of laws in this webinar. So in Texas, you can certainly intervene. When you talk about third parties, you can recover against a UM carrier or benefits paid by a UM or UIM carrier, provided the policy, the UM policy, is that of the employer. If the employee has a UM policy, you won't be able to subrogate to any of those benefits, and but if it's the employer's policy, you can. And we handled the case down in Texas that first granted those rights, employer's casualty versus Dias. If there's medical malpractice, This means you're paying benefits to an employee, and one day he starts treating for some other ailments, and it turns out that some medical negligence occurred which increased the payments you owe. You do have the ability to subrogate against the medical provider who was negligent, but you will be limited to recovering only those benefits which flowed from that malpractice. So if a woman breaks her arm on the job, you have to pay for the treatment to the broken arm, the internal reduction, and all the treatment. And then if she gets hooked on painkillers because it was malprescribed, then you can start subrogating against the doctor for all benefits paid after that. And it becomes rather tricky as to what benefits would have been paid had there not been malpractice, and what benefits can you recover. In Texas, it also allows you to recover against legal malpractice if an attorney drops the ball and doesn't file a third-party suit or negligently lets the suit get dismissed, and the plaintiff, the employee, sues his lawyer. You have the right to recover your lien out of that, and that's rare because most states are either undecided or say no on that account. Allocation of recovery, the carrier has a first money right of recovery, and I'll be going through each of the 10 states we're going to cover in this order, covering these 5 topics and any other issues that may arise. In terms of employer contribution, after 1/1/2003, there is a proportional reduction in your lien recovery based on the negligence of the employer, and they're submitted as a responsible party to the court, and then the court or jury determines how much the employer was at fault, and there's a manual reduction done proportionally of any recovery as a result of that negligence. Attorney's fees and costs, in most states, when you have a workers' compensation lien and the plaintiff has an attorney who prosecutes and maybe even tries the case and makes a recovery, you will owe attorney's fees in a number of states and costs a pro rata share. If your lien was half of the recovery made in the third-party case, you will owe half of the plaintiff's attorney's fees and costs, and likewise, it's a pro rata situation. And in many states, you can defeat that requirement to pay benefits if you are active in the case, if you engage subrogation counsel, if you have done material things in the investigation that plaintiff's counsel later relies on and needs to help them in the case. So all of that time you spend investigating has value in almost every state when it comes to making an argument that you shouldn't have to pay such a large amount of attorney's fees and costs pro rata to plaintiff's counsel. So in Texas, fees are apportioned by the judge. Future credit, yes, you have the right to a future credit in Texas, but you can recover a future credit whether the plaintiff sues or whether you sue and file your own subrogation action. You can sue for $1 million, even though your work comp lien is only $100,000. And then you just basically take your attorney's fees off the top, reimburse yourself your $100,000, and pay the balance to the employee, who then that amount becomes a future credit, and you can proceed in that way. So that is Texas. There's really no other significant issues in Texas that we'll get into today. Illinois is one of the most problematic workers' compensation subrogation states because they've forgotten the history. They have forgotten that workers' compensation is a compact. It was a deal that we made with the employer, and in Illinois they allow the employer to be brought in as a third party. So in Illinois, we do have the right, under subrogation rights, to file suit 3 months before the statute of limitations runs. Any release of the third-party action by the employee is void unless it's done with the consent of the carrier, or the carrier is protected by a court order or an indemnification agreement. But we do have the right to file within 3 months before the statute of limitations runs, so sometimes there's some waiting if the claimant isn't filing suit. In Illinois, we cannot subrogate against UM and UIM benefits, but we can subrogate against medical malpractice benefits. We cannot subrogate against legal malpractice benefits. And the formula in Illinois for allocating a recovery is simply the carrier gets the first money off the top less a pro rata share of attorney's fees and costs. And attorney's fees and costs is about the only silver lining in Illinois, is limited to 25%, whereas in many other states it's generally limited to a third, and in some situations can be up to 40%. There is a future credit given in Illinois, but the future credit is a little bit different. You basically don't get to stop making payments like you do in Texas, but you will owe 25% of future benefits as an attorney's fee reimbursement if, as, and when those benefits are paid. So that's how you get a future credit. Basically, you get a vacation for 75% of all future benefits that you owe. Now, just briefly, Illinois law is not clear on the exact procedure to be followed when an employer is sued for contribution by a defendant in a third-party action. It appears that based on all the available case law and parallels drawn to Minnesota and Idaho law from where Illinois got its notion of contribution, that the defendant pays the entire verdict. The employer then contributes to the defendant an amount that's commensurate with its liability in the Work Comp Act, and the employee reimburses the employer its subrogation interest pursuant to Section 5B. In other words, if the employer is 10% at fault and there's $1 million judgment, the employer owes $100,000. And if its lien is only $50,000, the issue becomes whether or not it has to pay the full 100 or only waive its lien of $50,000. And that depends on something called the Kotechi cap. Generally, an employer is limited to contribution for the amount of its work comp lien. But that cap, known as the Kotechi cap, can be waived in contracts which require and have indemnity provisions in it, and those are very common, especially in construction settings. Obviously, if you have an employee driving down the road and gets rear-ended by a truck, there's not a whole lot of argument that can be made for employer negligence in that situation, but on construction sites, and we see a lot of them, there is. In Missouri, Missouri is a very good state for workers' compensation subrogation. We do have the right to file suit on our own in Missouri. We do have the right to intervene into an action filed by the filed by the employee, but we're not required to. We just simply have to put people on notice. But there's always a danger when you put people on notice and you're not active in workers' compensation subrogation. What happens is, and this is about a half-hour subject in and of itself, all of the ways that the plaintiff can gerrymander, reconnoiter, redistribute, reallocate settlements and recoveries such that your lien is either significantly reduced or eliminated altogether. All of a sudden you'll find that defendants against whom you can't subrogate in the death case are out of the case, and all of the money is being paid by a to a non-beneficiary, and that can create havoc with your lien. Gerrymandering occurs all the time. And of course, you will always be told that the case is no good and you need to waive your lien, etc. So this is where, when I talked earlier about attorney involvement, it is significant. So in Missouri, there is a question as to whether or not you can subrogate against UM and UIM benefits. It's not fully established in law, but it is established that you can recover in a medical malpractice case, and it is, also undecided about whether you can subrogate in a legal malpractice case. With regard to attorney's fees, there's something called the Rudiger, when you're allocating a recovery, there's something called the Rudiger formula, which is followed. Basically, the plaintiff's attorney's fees and expenses are paid first, and the balance is apportioned based on the ratio of the lien to the total recovery, total third-party recovery. And then any amount left over is paid to the employee, and that constitutes a credit. And that's the Rudiger formula is something that's followed in Missouri. Under Missouri law, when you have Missouri benefits that are being paid. There is no employer contribution, and attorney's fees, once again, are distributed or owed by the employee, by the carrier pro rata. And in order to do that, the employee and his attorney must, quote-unquote, effect a recovery. There is a future credit, and there's a 5-year statute of limitations for personal injuries, which is pretty useful. Mississippi. Mississippi is a fairly good state to subrogate in. It does allow you to sue the third party directly for subrogation, or you can intervene, but if you sue on your own, you have to give reasonable notice, and any settlement has to be approved by the court. If the suit is filed, or by the commission, if no suit is filed. So if you have a suit filed, the court has to approve it. If no suit is filed, if you simply settle, then the commission has to approve the settlement, and you want to make sure that you do that. You can intervene. You cannot subrogate against UM and UIM benefits, no matter whether it's the employee's policy or the employer's policy. You can subrogate in medical malpractice, and legal malpractice, as it is in many states, is undecided whether you can subrogate against the legal malpractice recovery. And the allocation formula used in Mississippi is straightforward and very common among states. First, attorney's fees and costs are deducted from the gross settlement or recovery. Number two, the carrier is fully reimbursed, but in Mississippi there are no attorney's fees owed. This is a very strong tool for us because we don't have to negotiate. The old adage of, well, we'll take a third, plaintiff will take a third, and we'll give a third to the plaintiff's attorney. You do not have to do that in most states. It sounds like a fair thing to do, but is it really? Because the plaintiff and his client are getting 2/3 and you're getting 1/3, despite the fact that you have a statute which says you get paid fully, completely, 100%. So think carefully about that before you simply raise the white flag and say, okay, we'll do a third, third, and a third. One of the things I like my clients to walk away from one of these webinars with is the adage that you never have to do a third, third, and a third when you're making a recovery like that. Simply don't agree to it. I mean, our job, your job when you're taking off your claims hat and putting on your subrogation hat is to be yelled at. That's what I do for a living, is when I go into the mediations on your behalf, I'm the one taking the guff from the judge, from plaintiff's counsel, from all the parties, because I'm the one who supposedly is the fly in the ointment, even though I am the one, my client, the work comp carrier, is the one who was supposed to get that money back, thinking all the way back to history and the purpose of workers' compensation. Again, this is why the history is important, and I've told that history story in many a mediation. In Mississippi, you do get a future credit, and the court ascertains future comp liability and adjusts the division of recovery accordingly. Or you can suspend your payments the traditional way. You simply stop making benefits until the future credit, is used up. Arkansas. So this brings us home. Arkansas is a problematic state because it's one of the few states that has become infected with the quote-unquote made-whole doctrine, which really has no place in workers' compensation subrogation. The idea that, well, the big workers' comp carrier gets paid premiums to pay these benefits, it really shouldn't recover anything back until the employee has received all of his damages, is really misplaced. It's nice sounding. It's compassionate sounding. But historically, it's inaccurate, because what's really uncompassionate is the fact that an employer who has done nothing to cause an accident, who has not in any way, shape, or form caused a serious accident to its employee, should suddenly and potentially be on the hook for millions of dollars in medical expenses and indemnity lost wage benefits. Why is it that the employer is found liable automatically? Simply because the employer works for him. This is contrary to the common law system of civil justice we have in this country. So, the made-whole doctrine, when it creeps in, as it has in Arkansas, is a little disconcerting. But in Arkansas, we do have the right to sue on our own. We have to give 3 days notice. We have to give notice, and we also have to give 3 days notice of settling. The employee can settle around the carrier in Arkansas by splitting off his cause of action, but the carrier can still proceed on his own against the third party, so the carrier can't veto the settlement. This is why Arkansas is a must state, as is Texas, as is Missouri, to have subrogation counsel. And California is the same way. They're the classic state which allows the plaintiff to settle around us. In Arkansas, you must intervene in a reasonable time after notice. Arkansas is a minefield because if a file gets lost or falls into a pigeonhole somewhere and too much time passes, I don't care how big your workers' compensation lien is, you will lose it. Money that is easily recoverable simply because the file sat somewhere. So you must be proactive in getting an intervention filed as soon as possible after you know there's a third-party case. And plaintiff's attorneys are creative in arguing that you knew about it because in the medical records you have, the claimant mentioned in his medical history that his attorney was filing suit. So it could be something as simple as that they will argue gave you notice. You can recover against UIM benefits in Arkansas if it's the employer's policy. You can't if it's the employer's policy. You can subrogate against MedMal. I'd strike that. I argue you can. It's, according to the current state of the law, it's undecided. And it's also undecided in legal malpractice. But undecided means we can make law. So whenever you hear that term, it's undecided, that means if you have a good case with good facts, let's talk about it because we could make some law. The allocation, the formula sounds real good to start with. The costs and fees come off the top. 1/3 of the recovery goes to the employee, 2/3 goes to the carrier, and the rest to the employee. And if the 2/3 is not sufficient to reimburse the carrier's lien is reduced accordingly. This is a formula that's very popular, one that's used in Wisconsin, except in Arkansas they now employ the Franklin formula in workers' compensation. The measure of reimbursement for the carrier is the third-party recovery plus the insurance benefits must exceed the plaintiff's damages, his loss. If so, the worker is made whole. Comparative fault does reduce recovery, and so the made whole doctrine almost always raises its ugly head because plaintiffs' attorneys will never admit that their client has been made whole. Why should they? The law is giving them a freebie here. And so, again, Arkansas is a very important state to be active in. There's no employer contribution. Attorney's fees are allocated pro rata, and there is a future credit. Wisconsin, one of the most favorable states for workers' compensation subrogation. It's also the very first state in the nation to have workers' compensation, all the way back to 1911. And the statute, section 102.29 in Wisconsin, is very favorable. The carrier can sue the third party directly, recover all of the damages, reimburse itself completely, and any amount that the plaintiff receives constitutes a credit. Wisconsin, if it has any mark against it, you cannot subrogate against UM and UIM benefits, but you can subrogate against medical malpractice. You cannot subrogate against legal malpractice, and the formula is very, very much like Arkansas's. Attorney's fees and costs come off the top. 1/3 of what's left goes to the employee, and that does not constitute a credit. He just gets it free and clear so he can spend it. 1/3, the carrier is reimbursed fully, and any balance goes to the plaintiff, and that does constitute a future credit. There's no contribution. There is no responsibility for attorney's fees on the part of you, the carrier. And as I mentioned, there is a future credit. So Wisconsin is a very, very popular state. And also, and see, there's so many things we can get into. Wisconsin has a mandatory, you must be named as a involuntary plaintiff in a lawsuit under section 803.03 in Wisconsin. So you will almost always be served with a citation if you're the work comp carrier, or at least you should be as an involuntary plaintiff, although lawyers here like to skirt the rules and name you as an involuntary defendant. In Oklahoma, Oklahoma is an okay state to subrogate in. You can sue the plaintiff directly. You can intervene, and it's often advisable. You can't recover UM and UIM benefits, but both med-mal and legal malpractice are viable sources of recovery and reimbursement for a work comp carrier. When there is a recovery, fees and costs come off the top. The balance is pro rata distributed between the carrier and the plaintiff. If the recovery is a compromise settlement, which means that the amount is less than the lien, the amount of the recovery is less than the lien, then the court gets involved and can equitably apportion and translate that to screw the carrier. They can, and they almost always side with the employee because they too have forgotten the history of work comp and the purpose of work comp subrogation. But if the recovery isn't a compromise settlement, you follow the what's known as the Prettyman formula, and this means that the Prettyman formula basically says in a compromise settlement, the employer settles for less than the work comp lien, and this means settling for an amount less than the workers' compensation carrier's liability. It does not simply mean that a third-party action is settled as opposed to tried. When you hear the word compromise settlement, it just sounds like settlement. That's not what it means. It simply means that you're recovering less than the lien. But the future credit can be had only if the recovery is more than the lien in Oklahoma. And there's a 2-year statute of limitations. Again, all of this is covered in great detail in the book, Workers' Compensation Subrogation in All 50 States. Nebraska is a good state to subrogate in. You can file suit against the against the third party with notice, and they've had some legislative changes there, but you can intervene and you have an equal voice in the litigation in Nebraska, as you do in Texas and Wisconsin. You possibly, you can subrogate against the employer's policy for UM benefits, possibly against the employee's policy. That's a little up in the air, but definitely for the employer's policy. You can subrogate med-mal, and it's undecided whether you can subrogate for legal malpractice in Nebraska. The allocation formula in Nebraska was good. It simply said fees and expenses come off the top. The carrier gets reimbursed fully. First money right of recovery, much like in Texas. Next, and then if there's anything left over, it goes to the plaintiff, and that constitutes a future credit. However, case law came around, and now this division, this allocation of the recovery must be agreed to, or if it's not agreed to, the court can approve any allocation that it deems to be fair and reasonable. 1 second. I apologize. Attorney's fees are recoverable and allocated if the carrier was active. If not, there's an automatic pro rata deduction from the comp lien. What does this mean? That Nebraska is one of the many states, like Texas, in which you can defend against attorney's fees being taken out of your lien by being aggressive in recognizing subrogation and doing your investigation, supplying that investigation to the plaintiff, getting subrogation counsel involved. And if you think this is chicken feed, a $300,000 lien, you are literally saving $100,000 simply by being active in the case. There is a right to a future credit, and there's a 4-year statute of limitations in Nebraska. We get to Iowa. Iowa is an interesting state for workers' compensation subrogation. In Iowa, you do have the right to subrogate and file suit on your own, but you have to give 90 days notice in order to do so. The plaintiff has to give you merely 10 days notice before trial, so you might get notice that a case is being litigated and there's a trial in 10 days, and then you have to call us and get us involved to protect your subrogation interests, which just seems a little unfair. But if there's a trial going on, it simply means that somebody missed the boat. We should have recognized subrogation and either initiated it or got involved on our own rather than waiting to be called by plaintiff's counsel. In Iowa, you must intervene within 30 days of receiving an employer's notice, or you lose your subrogation rights. You have to take action and the intervention must be timely filed. You can't subrogate against UIM benefits. You cannot subrogate against med-mal, and cannot subrogate against legal mal. But once we get all those obstacles gone, we do have a first money right. And just be aware that in Iowa, Section 8535, if you settle a contested comp claim, it could bar the subrogation recovery. So you have to work with subrogation counsel even when you're settling a compensation claim there. There's no employer contribution. There's a pro rata sharing obligation to pay attorney's fees on the part of the carrier. And you also get a future credit. But in Iowa, you are allowed to recover your future benefits in a third-party suit that you file. So you not only recover your lien, but you recover your reserves as well, as long as you prove them up. And there's a 2-year statute of limitations. Kansas, interesting state. For some reason, I have a lot of workers' compensation claims in Kansas involving Nebraska employees. And we have an hour-long webinar on conflicts of laws and subrogating across state lines. Extraterritorial subrogation is what we refer to it as, and that's an important area of the law to understand. We're not getting into it today, but just know that where you have someone subrogating in one, filing suit in one state, receiving benefits under another state, that it's possible to avoid the bad law of the state in the forum by applying the subrogation law of the state where the benefits are paid. Kansas allows us to file suit after 1 year or 18 months if there's a death. So you have to wait a year, then we have the right to file suit on our own. We can intervene, and as far as and UIM subrogation goes, in terms of third parties, we only have the right to subrogate if a substitute payment is made by the UIM carrier, which is a real disincentive for UIM auto carriers to make that substitute payment. But med-mal, we can subrogate, and it's undecided whether we can subrogate against legal mal in the state of Kansas. The allocation formula applies something called the Brabander formula. This is a formula which basically says that our lien extends only to damages which duplicate medical and lost wages. Here again, they've lost sight of history and have sort of tried to constrict our recovery rights by saying, well, you don't get your lien paid out of everything that the claimant recovers. Only those damages the claimant recovers which represent medical expenses or lost wages. And here again, what do you think an entrepreneurial, innovative trial lawyer is going to do? Well, he's going to gerrymander that settlement so that he's not recovering these duplicated medical and lost wages. He's going to be recovering pain and suffering, mental anguish, physical disablement, non-economic damages to which you're not subrogated. So an employer negligence does play a role in Kansas under the Brabander formula. There is a reduction for the employer's negligence. Basically, it's the lien minus the damage award times the % of the employer's negligence. Now, you could see I could spend an hour, I could spend 2 hours on Kansas work comp subrogation alone because of how complicated some of this gets. And anytime there's complication, it equates to opportunity. Complication works to the advantage of those who understand the complications. And that's why education in subrogation is valuable, because most trial lawyers don't understand the nuances of subrogation. And if you do, you have the ability, especially from the start, to prepare for and fashion the case in such a way that it benefits you. Classic example is if you know two states are going to be involved, maybe you can steer the claimant to accept Texas benefits as opposed to Georgia benefits, because if he took Georgia benefits, he might not be able to subrogate at all. That's what the benefit of understanding the law. Attorney's fees are apportioned, but there's if you're active, Kansas does remain a state where if you get counsel, you are active in the case, you do have a defense against attorney's fees being taken out of your lien. And if the plaintiff tries to do the things that I claimed they will do, in Kansas, you do have a defense against an attorney's fee. Basically, you can say, Judge, the plaintiff's lawyer tried to screw me, and now he's asking to be paid for the fact that he wasn't successful in screwing me out of my lien. So that's an opportunity, at least in Kansas. Any future credit, you do get a future credit, but it's reduced by the amount of the employer's negligence, and there is a 2-year statute of limitations in Kansas. So I'm trying to stay on time here, and I understand we may be moving a little quickly. But let's move on to auto subrogation. Here are some reasons why auto subrogation is critical. 275 million reasons why we should become very familiar with automobile subrogation law and negligence law in the states in which we are subrogating. More than any other country, 275 million cars. During this webinar, 10 people will die in the country in car accidents. There's 45,000 people killed annually, 115 per day, and for every 100 insured cars in 2010, there were 5.67 collision claims and 2.61 comprehensive claims. We're talking billions and billions, the majority of which we do not subrogate even though we could. And so we're talking about a lot of money. If insurance companies look only to their premiums and their investments for income, they're missing one of the largest sources of income. And I think over the last economic downturn we've had, subrogation has been more of a source of income than has the investment part of underwriting. Subrogating medical and property claims. There's different types, and I wish we had more time to spend on some of this. It's important for you to understand that there are 3 types of subrogation. There's contractual, aka conventional subrogation. This is the subrogation that you get by virtue of the plan language contained in your insurance policy. It's also the sort of subrogation you get when you enter into a subrogation agreement with an insured. On the other hand, equitable or legal subrogation is simply subrogation which occurs as a matter of law. No policy terms are needed. If you pay something that satisfies a debt owed to a third person, then you are subrogated automatically by operation of law to the rights of that debtor to recover money from the debtor. In the auto accident case, obviously you are automatically subrogated to the rights of your insured against the guy who hit your insured in the collision, or the driver if your insured was a passenger. So, but with equitable and legal subrogation, the made whole doctrine, the doctrine that says the insured must be made whole before you, the carrier, can subrogate and receive 1 penny, does come into play because it is an equitable doctrine. And the common fund doctrine, the doctrine which says that you as the carrier are going to owe the plaintiff's attorney a pro rata share of the attorney's fees that the insured incurred in prosecuting the case and creating the fund out of which you got your subrogation recovery. Again, both equitable doctrines, and one of the problems we're having in this country is these equitable defenses, made whole doctrine, common fund doctrine, are being applied to contractual or conventional subrogation, which is not the case. And courts are doing this by saying, well, we just consider contractual subrogation to be an extension of equitable subrogation, which is totally untrue and is basically a creative way to help get money in the hands of the employee or the insured. Lastly, there's statutory subrogation. This can be PIP and MedPay subrogation, which we'll talk about. It could be workers' compensation, which we have talked about, or Medicare and Medicaid subrogation. But it is different and usually stronger than equitable or contractual subrogation. All right, I'll go over this quickly, but I think we understand that MedPay coverage pays for medical expenses of the insured and passengers in any auto accident or as pedestrians, regardless of fault, and the law changes from state to state. As we move through this quickly, I want to just take a second to say this. It sounds like there's a lot of material, and as you glance down at the notes, you see that you can hardly read what you've written because we are moving quickly. Keep in mind that our website has Numerous webinars, including this one, will be on there for you to revisit and replay. It has charts covering workers' compensation subrogation, the basics in all 50 states. It has a chart which delineates the law we're about to go over with regard to MedPay and PIP subrogation for all 50 states. And again, it is only a chart, and while we love here, I guess people love their lives to be reduced to charts because it's simple. You can look and see and say, oh, I fall here. Unfortunately, subrogation isn't always that black and white, but these charts are very helpful to you. And so you can check those resources out. You can print them off and use them. They're updated regularly from our website to help you get a lot of this information. Getting back to MedPay and PIP, PIP coverage pays first-party medical expenses, lost wages, and funeral benefits for insureds and passengers. No-fault states are required. No-fault states require PIP, and I've listed some of those there. And this is often associated with the no-fault insurance. Some states provide for MedPay benefits, but not PIP. And other states are add-on states. So we have normal common law states. We have no-fault states, and then we have states like Texas and a few others where it's not a no-fault state, but they have PIP available as an add-on in certain amounts, usually small amounts, 5,000, etc. MedPay and PIP subrogation. No-fault pays first-party medical expenses and lost wages, damages to the insured without regard to fault in exchange for the insured limiting, usually, their right to sue the tortfeasor for certain types of damages. So these states limit and put conditions and benchmarks on when and if you can sue a third party. Sometimes it depends on the weight of the vehicle or whether you were a passenger or a driver or how much or what the facts were. But no state has absolute no fault. In other words, they give up the right to sue completely. Michigan is the closest we have to absolute no fault, but just know that no state is absolute no fault. Auto insurance laws today fall into 4 categories. As I mentioned, the traditional tort system, no PIP, but they have, and no restrictions on suing anybody. Add-on states, we're going to cover some of these. These are optional PIP states where there's no restrictions on suing. Modified no fault. This is where first-party benefits are paid without regard to fault. You must meet a monetary or a verbal threshold in order to sue, and I give some examples there. Or choice no fault. In these states, the insured has a choice of pure no fault, no suit for non-economic damages at all, or modified no fault, where you can sue the driver. And there's 3 states that have choice no fault, and those states, New Jersey in particular, can be very tricky. I mean, how much the vehicle weighs, what's the curb weight, is the trailer included in that? But we're not covering those states. So let's start with Texas. In Texas, hang on one second. We're going to go through the chart you see here is going to be look similar to the chart for the other 9 states that we covered. I will list the number of drivers in the state and what percentage of those drivers are uninsured. Obviously, a lot of the southern states down by the border have higher uninsured rates than they do up in, say, Idaho and Utah, where the uninsured rate can be anywhere from 2 to 5%. But we'll be going through on each state MedPay subrogation, PIP subrogation, collision and property subrogation, UM and UIM subrogation, the made-whole doctrine, the common fund doctrine, reimbursement of deductibles, and contributory negligence. That list you see on the screen in front of you is probably 1/3 of the issues that you should be familiar with when subrogating for automobile insurance in Texas or any state. But unfortunately, even limiting it to these bullet points, I'm going to have a hard time finishing on time. So I'll be flying, but again, you can re-listen to the webinar because it'll be posted online. And the best source, and I'll just be honest with you, it's the book. It's got answers to everything. So MedPay subrogation, in Texas, subrogation language contained in auto policies is valid and given effect in Texas. However, in Texas, contractual subrogation is considered to be equitable and therefore subject to the made-whole doctrine. You can subrogate MedPay subject to the made-whole doctrine in Texas. PIP subrogation is not allowed. Texas is an add-on state for PIP, but there's a statute, section 1952-155, that provides that a PIP carrier in Texas will have a right of subrogation against a person who does not have the required insurance. So if you're uninsured, you have an uninsured, you can't subrogate against them for PIP, otherwise you cannot. Collision subrogation, the main points we're going to be talking about, and there's many more, but the main points today are, can you subrogate for collision? And you can in every state that we're going to be discussing. And what are those damages? The plaintiff in Texas can elect between two methods of measuring property loss. He can recover the difference in the market value before and after the accident, or the reasonable cost of repairing the vehicle. In addition, Texas is a state which allows for loss of use of the vehicle. Plaintiff can prove damages for loss of use of a repairable car by establishing the reasonable rental value of a substitute car. But you cannot recover loss of use damages in Texas, even if you paid it under your policy, if the vehicle is a total loss. UIM subrogation is allowed in Texas, and they allow for substituted payment. There's the settlement without consent exclusions of a typical policy are enforced in Texas. So if the insured wants to settle with a UIM driver with minimum limits, he has or she has to get your consent. And if you don't want your subrogation rights destroyed, then you can say no, but then you have to make a substituted payment to the insured in the amount of the liability limits, minimum limits of the insured. I'm sorry, of the tortfeasor. Made whole doctrine in Texas, we have the burden of proving that the insured has been made whole. And in other words, if a subrogated carrier settles directly with a third party and the insured must file suit to seek reimbursement from the carrier, the burden is on the insured to prove. In other words, it's the party filing suit who has the burden of proving that the insured is made whole. That's important. And again, we get to strategy. And that's one way that we can try and get you 100% back, is avoid the made whole doctrine by waiting until the insured files suit and then they suddenly have the burden. That doesn't mean it's impossible. But however, in Texas, in a case that we handled, the Fortis Benefits case, the Texas Supreme Court specifically, and I say handled, we wrote the amicus brief for it. The Texas Supreme Court said that the made whole doctrine does not apply to contractual subrogation claims. In other words, your policy, the way it's written, can't override the made whole doctrine. And that's going to be one of the key concerns you have when talking about the made whole doctrine in any state. Common fund doctrine, an insurer does not insist in the collection of damages, must pay its pro rata share of costs. So again, it's a key reason to be involved in Texas. With regard to reimbursement of deductibles, Texas is the only state that has a statute which spells out what you have to do. If the carrier files suit, the carrier must include the insured's deductible with the damages being pursued against the tortfeasor. But this only applies to private passenger automobile policies. Contributory negligence, comparative fault. Texas is like most states which follow the modified comparative fault rule. This allows a plaintiff to recover damages against a tortfeasor even if the plaintiff is negligent, provided the plaintiff is 50% or less at fault. In Illinois, MedPay subrogation is recognized and upheld in Illinois, and Illinois subrogation is also complicated by the fact that when minors are involved, parents are primarily liable for the minor's medical expenses. So if you are trying to subrogate for a minor, there's something called the Illinois Family Expense Statutes. When an auto carrier makes MedPay payments to on behalf of a minor, it's to the financial benefit of the parents rather than the minor, and therefore the minor is neither the beneficiary under the terms of the policy nor a third-party beneficiary under Illinois law. So this is, again, where subrogation counsel is valuable, because we want to make sure that those parents are a party to that suit, not just the minor. And again, trial lawyers will set it up so that this minor's doctrine prohibits you from recovering your lien. PIP subrogation is not sold, and it's not relevant really unless it's for an out-of-state policy. Collision subrogation, This is obviously provided for in Illinois law, and in Illinois, the plaintiff can recover the reasonable cost of repairs, the diminution in value of the car even after the repairs, and his loss of use of the car for the time reasonable necessary to make the repairs. So it does allow for that. And a rental vehicle does not have to be obtained. For UM subrogation, subrogation is allowed, and provided the policy grants the insurer a valid right of UM subrogation. Now, Illinois does not apply the made-whole doctrine as a blanket rule, and it does not recognize the made-whole rule in the way that other states do. Illinois recognizes the validity of subrogation clauses, and it enforces them, and the effect of a subrogation clause is identical in Illinois to that of a reimbursement clause, which says the insurer will get reimbursed rather than simply having the right to file suit. So Illinois state courts will enforce contractual subrogation rights even if the insured is not fully compensated for all of his injuries. However, Illinois leaves the door open a little bit and may encourage the use of the made-whole doctrine in quote-unquote appropriate circumstances. With common fund doctrine, again, it's a good state for us to, in order for the doctrine to apply, the attorney for the insured must show he created a fund, that the plan or the insurer did not participate in the creation of the fund. Again, if we are participating, we can avoid paying those fees, and that the insurer benefited out of the fund that was created. So, you know, we might not benefit from some portion of that recovery, and so we shouldn't have to pay a fee on it. There's just all kinds of ways to skin that cat, but just know that that's an issue. There's a statute in Illinois. When I said Texas was the only statute, I meant it to be it was the only one which enunciated the procedure. But in Illinois, Section 5/143B says that when you're reimbursing deductibles, the insurer can deduct incurred expenses from recoveries on subrogated collision claims, but we can't deduct administrative expenses. Those terms are spelled out in the book as to what they mean, but that's just a good way of saying you don't have to reimburse the entire deductible based on that statute. Illinois is in the majority of states which follows the modified comparative fault rule. It allows the plaintiff to recover damages against the tortfeasor provided the plaintiff is 50% or less at fault. That's the normal rule, and most states follow it. Missouri is an interesting state. Missouri, like some states, is an anti-subrogation state. It prohibits the assignment of personal injury causes of action. That simply means that at one point they said, we don't want judges, we don't want lawyers to be running cases and signing people up and then assigning personal injury causes of action, and we don't want people to be selling their claims. So they hold that an assignment of a personal injury cause of action is void. Therefore, MedPay subrogation is not allowed, and it's against public policies. And any subrogation or reimbursement provision which is in a policy, even an out-of-state policy, is illegal and unenforceable. PIP subrogation in that state, PIP has no no-fault laws, and so PIP isn't really required. It may not be subrogated or reimbursed. Collision subrogation. Missouri also has a rule against splitting causes of action. I could spend 15 minutes, especially in states like California, explaining what the splitting cause of action means and how that can be used as a tool in your favor. But the splitting rule doesn't apply to property versus medical claims. So if the plaintiff and the insured brings a personal injury suit, you can bring a separate suit for damages, and that does not violate Missouri's rule. Loss of use damages can be recovered. Uninsured motorist carriers allowed subrogation rights for benefits that it pays out, but that's statutory, but Missouri provides no statutory right to subrogation with regard to underinsured motorist coverage claims. But the law on this is somewhat unsettled, and so that bears some looking into. The made-whole doctrine has never been expressly addressed with regard to priority of rights between an insurer and its insured in the context of conventional subrogation. The made whole doctrine is applied in Missouri, but hasn't been applied with regard to subrogation. But there was a recent case, well, I say recent, within the last 15 years, in which, in the context of the Delaware No-Fault Act, applied in Missouri, where it looks like they might go that way, but they haven't yet. So if you have plaintiff's attorneys just telling you, oh, well, we're not made whole, so you can't subrogate in Missouri, always go look to see whether that made whole doctrine applies in that particular state, and if it applies, how it applies. Can it be overcome? Well, who's got the burden? What has to be shown to prove that the insured was made whole? And most importantly, can we contract around it? Can the policy terms negate the made whole doctrine? So common fund doctrine, attorney's fees are not recoverable. Missouri recognizes the common fund doctrine for purposes of other areas of subrogation, but because they're an anti-subrogation state for MedPay, really doesn't get into applying it for MedPay. Missouri regulations require that the insurer include the insured's deductible in any subrogation demands, and that they're then shared on a pro rata basis if they recover. Missouri, for contributory negligence and comparative fault, is one of only 13 states which recognizes what's known as the pure comparative fault system. There's a couple others we'll talk about, but pure comparative fault allows a damaged party to recover even if he or she is 99% at fault, although your damages are reduced by the amount of your fault. So if you're 99% at fault, you'll recover 1% of your damages. Mississippi, subrogation under MedPay is allowed in Mississippi, but it is subject to the made whole doctrine, and the made whole doctrine is rather strong. There's no PIP subrogation in Mississippi. Auto property subrogation is permitted. The measure of damages is the diminution in retail market value of the vehicle. So the reasonable cost of repair of a damaged vehicle may be recovered, as well as remaining diminution in pre-accident value after the repairs, but in no event can the cost of repairs be recovered if they're more than the total value of the vehicle before the accident. So you have some options in Mississippi on that regard. With UM-UIM subrogation, both are allowed. And with as an alternative to withholding consent, in UIM cases, the UIM carrier can make a substituted payment to the insured in the amount of the tortfeasor's policy limits. That preserves subrogation. Mississippi doesn't differentiate between equitable subrogation and contractual subrogation, so it applies the made whole doctrine, and you cannot contract around it. With regard to the common fund doctrine, Mississippi does recognize the common fund doctrine, but they've yet to adopt it with regard to auto insurance subrogation. You will see all kinds of things as you attempt to settle your cases. Yesterday, I had one of the northern states where the made whole doctrine does not apply. The attorney found a 1981 letter written from a judge to the attorneys in a case he was handling, which said, I think the made whole doctrine should apply in this case. Please send me an order. It's not even a Court of Appeals decision. It's not even precedent yet. It's an old carbon copy of this letter that's been passed around among trial lawyers to try and get insurance companies to reduce their liens. In this case, he wanted them to take about 10% of the money they had coming, and I told him that it simply didn't apply. So made whole doctrine, you've got to watch out for that. Common fund doctrine in Mississippi, they are cognizant of this doctrine, but they've yet to adopt it with regard to auto subrogation. It's only been applied with regard to mortgages. Mississippi has no statutes, regs, or case law which govern reimbursement of an insured's deductible. I've talked to the insurance commissioner in every state when writing our book, and I can tell you that by and large, if there is no such regulation, generally what they recommend is a pro rata reimbursement. If you got 50% of your subrogation interest back, they should get 50% of their deductible back, but it is not required. But of course, it only takes one entrepreneurial, innovative trial lawyer to file a class action claiming you should be doing that, and we see a lot more of that lately. Give me one second. All right, let's move on to Arkansas, our home state. Traditional MedPay coverage is less common in Arkansas because you have a statute that requires PIP coverage, which includes a MedPay component. So they blend the concept of MedPay with PIP benefits, and subrogation of MedPay benefits is allowed to the same extent as the subrogation of PIP benefits. Under Arkansas law, an insurer only has a lien or right of reimbursement from its insured if the insured pursues a third-party tortfeasor. If the insured files a third-party action, the insurer does have a lien or a right of reimbursement out of any third-party recovery. So any claim involving subrogation of UM, PIP, or MedPay in Arkansas necessitates that the insured first file a third-party action. And the subrogated insurer must place its insured on notice of this, your subrogation interests, and it must monitor when and whether the insured has filed suit. Failure to properly and timely assert your lien may prevent recovery. So the onus is on the carrier in Arkansas to be proactive, to be attentive, and they only give you certain rights. Again, with regard to PIP subrogation, Arkansas blends the concept of MedPay with PIP. So subrogation of MedPay benefits is allowed to the same extent as the subrogation of PIP. Collision subrogation is allowed in Arkansas. The general rule is that the measure of damages recoverable in a tort case, again, this has nothing to do with your policy. You may have replacement value benefits paid in your policy. You may pay out $70,000 for a replacement for a new Escalade or something. But as far as the law is concerned, all you can recover is the difference between the market value of that automobile before and after a collision. In the absence of any competent proof, the difference in market value before and after the collision can be established by the total amount paid for the repairs necessitated by the collision. But the automobile owner is entitled to recover damages for the loss of use, in addition, even though the vehicle was completely destroyed. And that's unlike Texas. I'm sorry, Texas only allows it if there's repairs. UIM subrogation, Section 2389-405 sets forth your subrogation rights. They're pretty straightforward. They allow, but they have a detailed substituted payment procedure which has to be followed under 23-89-209C, and you should, that's spelled out in the book, but that should be followed closely. Under Arkansas law, the made-whole doctrine is recognized and dictates whether an insurer has a subrogation right. Courts are permitted to determine whether an insured has been made whole based on the facts that are presented to it, but there is no trial by jury on this issue, which is unfortunate because most of the time juries try to, a lot of the judges, if the plaintiff gets in a trial court's lawyers, plaintiff's judges chambers, that judge is going to rule on behalf of the injured employee, or the insured rather. So the relevant question is whether the insured's uncompensated, uninsured loss is greater than the net recovery from the tortfeasor. Almost never happens, and the plaintiff's lawyers will never agree that they've been fully compensated. The common fund doctrine is applied. They've codified it in Section 2379-146, and you're responsible for the reasonable costs in a proportion that each benefits from a recovery. So again, here's an opportunity for you to be active and to avoid paying attorney's fees. Arkansas Administrative Code, not a statute, but the Administrative Code, the regs, govern the reimbursement of deductibles, and it provides that the insured's deductible must be included in any subrogation demand, and then the insured is entitled to a pro rata reimbursement. And Arkansas has modified comparative fault. It's a 50% bar, which is the second most common. It means that a plaintiff cannot recover if he's 50% or more at fault. If he's 49%, he can recover, although his recovery is reduced by 49%. Wisconsin, Med-pay subrogation is allowed in Wisconsin. Common law subrogation requires that the insured be made whole. Give me one sec. I got to get a drink. I apologize. But in Wisconsin, I think it's important to keep something in mind. Wisconsin is a big made-whole state, and Wisconsin requires med-pay, requires subrogating carriers to prove that the insured is made whole. But in Wisconsin, these med-pay subrogation, unlike most states, is a statutory right of subrogation. There's a case set forth in the book, and it's set forth in some of our newsletters, which are also on our website, Waukesha County versus Johnson, that dealt with Section 4965, which is a statute providing for statutory public assistance subrogation. And it says, but in a long story short, the case creates an argument that Wisconsin med-pay subrogation is not subject to the made-whole doctrine because they say that statute, the court said the statute rendered the common law subrogation principles inapplicable if you're seeking reimbursement under that section. Well, we're seeking reimbursement under a statute as well in med-pay, and therefore that logic should apply. Now, there is no case saying that med-pay subrogation is not subject to made-whole, but it would seem logical that it is. PIP subrogation, Wisconsin does not have no fault or PIP. Auto collision subrogation is allowed. Plaintiffs are entitled to recover either the reasonable cost of repairs or the diminution in fair market value of the vehicle, whichever is less. So they don't get a choice. But if the plaintiff proves that after repairs there is a loss in value of the vehicle, the plaintiff is entitled to damages for that proven loss value. subrogation is allowed in Wisconsin. This is true for both uninsured and underinsured benefits. And there's the something called the VOT procedure, VOGT procedure for substitution of UIM benefits, which is explained a little bit more in the book. Not only has Wisconsin adopted the made-whole doctrine, but it's sometimes referred to as the mother of all made-whole states. This is where made-whole got its origin back in 1977. The common fund doctrine is applied in Wisconsin, but only, and here's the opportunity, only if three prerequisites are fulfilled. Number one, monies received from the tortfeasor must be created or brought into being solely by the efforts and steps taken by the attorney for the insured. That word solely is key there. If we help, we don't owe common fund fees. Secondly, notice must be given to the carrier that an action has been commenced and that a reasonable fee will be requested unless the subrogated party joins in the action. If you don't get that letter, you won't owe common fund fees. And third, if the subrogated carrier does not become a party to the action. So remember, Wisconsin, become a party to any action that will automatically save you 1/3 of your subrogated interest. Excuse me, reimbursement of deductible, there's no really code here, but the Office of the Commissioner of Insurance has indicated to me over the phone that they wouldn't quote-unquote object if the insurer reimbursed on a pro rata basis and reimbursed by the percentage of comparative negligence of the insured. So, but that's not required. That's just, I guess, their wish list. Wisconsin is a 50%, a 51% bar. I'm sorry, it's a 50% bar. Where in the majority of states we followed modified comparative fault, and the plaintiff can recover damages against the tortfeasor if the plaintiff is 50% or less at fault. So if the plaintiff is 51% or more at fault, it cannot recover. Oklahoma, and again, I'm trying to move a little quickly here. MedPay is allowed. I'm going to try and hit some of the highlights. Oklahoma is a no-fault state, and PIP coverage is not allowed. Collision subrogation is allowed. And the damages where the injury to an automobile that has been partially damaged by the negligence of another is susceptible to repair. The proper measure of damages is the cost of repair. But if repairs fail to bring a damaged vehicle up to the condition it was prior to the damage, then you can sue for the difference in value before and after. UIM subrogation is allowed, and it has some rather interesting quirks with regard to notice of tentative settlements. A carrier can adopt to substitute payments under a procedure under Oklahoma statutes. The Maid-Whole doctrine has been applied to health insurance, but not to automobile insurance, at least until 1994 when the 10th Circuit applied it to a UIM case. Now, chances are that it will probably be applied when the case comes down the pike to other types of auto insurance, but right now, what you simply say is, show me a case that says the Maid-Whole doctrine applies to MedPay subrogation, and we'll, of course, consider reducing our subrogation interest. Common fund doctrine is recognized, but it's never been applied in Oklahoma in auto subrogation cases. So you can see that simply because you deal with the common fund doctrine in one state doesn't mean it necessarily applies in another. Reimbursement of deductibles. Oklahoma code provides that we must include deductibles in subrogation demands, and subrogation recoveries are shared on a pro rata basis with the insured. Contributory negligence. Oklahoma is, again, in the majority of states, modified comparative fault, and if the plaintiff is 51% or more at fault, it cannot recover any damages. In Nebraska, MedPay subrogation is allowed, but there's an irrebuttable presumption that an insured who settles for less than the liability limits of a tortfeasor has received full compensation and is entitled to subrogation to recoup MedPay benefits without being harassed by the Maid-Whole doctrine. That's important to recognize and remember. And that case is Millbank Insurance Company versus Henry, 1989 Nebraska Supreme Court case. I cite it often. No PIP. Collision subrogation is allowed. Repair cost is the measure of damages, but it can't exceed the market value before and after. And subrogation is allowed in Nebraska. There's notice provisions that have to be given by certified mail by the insured to the UIM carrier of any intent to settle with the tortfeasor with the minimum limits. And then the UIM carrier has 30 days from receipt of that notice letter from which to substitute its own funds. The Maid-Whole doctrine applies in Nebraska, but it's unsettled whether it can be overwritten or by contract, but the odds are that it cannot. However, as I've indicated, there's a defense to it in Nebraska. The common fund doctrine does apply where the plaintiff's attorney expends time and effort to create a common fund and the party has substantially benefited. There's an argument that can be made in Nebraska. There's a case out there where you can say, look, all we have are medical benefits, and there's not a lot that's contingent about the recovery for medical expenses because those are the most basic elements of damages, and they're liquidated economic damages that are easy to ascertain. Therefore, it may be difficult for an attorney to prove, and they do have the burden to prove, that you, the subrogated insurer, received a substantial benefit, and the common fund doctrine may be defeated in that way, which is something good to know. Reimbursement of deductibles. There is an administrative code section that requires that we include the deductible in any demand, and that it's shared pro rata. That seems to be the consensus from state to state as these things start to proliferate. Nebraska is a common comparative fault state. Modified, it's one of 11 states which follow the 50% bar rule, which is, it seems like it's only 1% away from the 51% bar rule, but having tried cases for 30 years, I can tell you a lot of times juries just throw up their hands and say, well, 50-50. Well, 50-50 isn't going to get you recovery in a state like that. Just know that that's the law in Nebraska. In Iowa, MedPay subrogation is allowed provided the policy has the appropriate subrogation language and subject to Iowa's unique version of the Maid-Whole doctrine. I'll get to that in a sec. No PIP coverage required or offered in Iowa. Collision damage is recoverable and subrogable, and it's the reasonable costs of repair is the proper measure of damages. And where the vehicle can be repaired, the measure of damages is that cost of repairs plus the value of loss of use. So you can recover loss of use as well as cost of repair is the traditional measure of damages where the car can be repaired. UM subrogation is allowed and protected by the consent to settle clauses. The made-whole doctrine applies, but here in Iowa, the Supreme Court has held that an insured need not be paid in full for pain and suffering and disability prior to allowing subrogation for medical expenses. So you can see how every state has its own little nuance. So in this state, according to the court, any other rule would make insurance companies the indemnitors of losses not covered by the auto policy. That makes sense, and it would operate as a windfall to the insured who hadn't paid for that kind of coverage. So in Iowa, while you can't contract around the made-whole doctrine by your policy terms, you don't have to be made whole for pain and suffering and disability prior to allowing subrogation for medical expenses. You just have to show that the plaintiff recovered for medical expenses. But of course, they'll try and work the settlement so that doesn't happen. There's a pro rata reimbursement of deductibles required. I apologize. Iowa does recognize the common fund doctrine as well, and there's some nuances to that, but know that can be defeated. Contributory negligence, Iowa is a 51% bar state, pure comparative fault. Kansas, and this is our last state, MedPay subrogation in Kansas is allowed. I'm sorry, I strike that. It is not allowed. MedPay subrogation other than is provided for with regard to PIP subrogation because of the states that we've looked at, the 10 states that we've gone over. Kansas is the only true no-fault state. So where MedPay coverage in an automobile policy is not identified as PIP, medical payments paid out under that coverage are not subject to subrogation under the statute which allows for PIP subrogation, section 40-3113. So Kansas allows PIP, no-fault subrogation and reimbursement with some rather significant limitations. If the insured files suit against the tortfeasor, then the PIP carrier has a right of reimbursement and a lien to the extent that PIP benefits were duplicated in the tort recovery. See, now, what does that mean? That means that there's opportunities for the trial lawyers to gerrymander a settlement. The PIP carrier can enforce its lien by intervening. The insured, however, maintains full control. So it must be remembered that a subrogated PIP carrier steps into the shoes of the insured and may only recover those damages which are in excess of the monetary threshold of $2,000. We haven't had time to get into how no-fault states work and the different thresholds, but this is a monetary threshold in Kansas, and the plaintiff can't sue the third party unless damages exceed $2,000. So neither can you. If the insured does not initiate the third-party action against the tortfeasor within 18 months after the date of the accident, there's an automatic assignment to the carrier of the insured's cause of action with respect to those PIP payments. And if in that event, the PIP carrier can file suit either in its own name or the name of the insured. Care should be taken when subrogating PIP in Kansas, though, because there was a State Farm automobile, or State Farm Mutual was cited for violations of the Unfair Claims Practices Act back in late 2006 because it did the following, and I'm just going to read a couple of the practices that it engaged in which you need to be on the alert for in Kansas. Number one, it provided subrogation notice prior to the 18-month period specified by the statute. Don't do that. Number two, subrogating before PIP payments exceed the $2,000 threshold. Don't do that. Number three, subrogating for PIP payments in a state outside Kansas where PIP could not be subrogated. Don't do that. Number four, commencing subrogation efforts before the 18-month period expires. Not acknowledging the interest of the insured's attorney during the 18-month period. those are 5 of the main things that they cited State Farm for. Collision subrogation is allowed in Kansas. It can recover the cost of repairs necessary to restore the vehicle, and but it can't exceed the value of the vehicle in total. In Kansas, both UM and UIM carriers have a statutory right of subrogation. In a UIM claim, the insured will have a claim against both the tortfeasor that is underinsured and his own UIM carrier. So most UIM policies require, again, the consent to settle, and a substitute payment can be made. The made-whole doctrine applies in Kansas, but it's largely inapplicable to the subrogation of medical expenses because, of course, Kansas is a strong anti-subrogation state. There is no subrogation of medical expenses because of the no-fault rule, with those exceptions. If a policy is issued in another state or property damages are being subrogated, the made-whole doctrine may arise. But there's little case law and little guidance in Kansas with regard to how the made-whole doctrine will be applied. And again, that can work to our advantage. Common fund doctrine, it applies sparingly because Kansas is, of course, an anti-subrogation state, no-fault state with regard to medical expenses. But when subrogation is allowed, such as with, as I mentioned, property damage or policy exempt from the anti-subrogation statute plans issued in other states, Kansas appears to be leaning toward application of this doctrine, the common fund doctrine, although there's no cases that apply it in an auto context. So again, when the plaintiff's lawyer says, hey, reduce your lien by 1/3 for me, what you say is, give me some authority. And he sends you a case, you can say, well, that doesn't apply to PIP subrogation or property subrogation. Reimbursement of deductibles. Kansas has no statutes, regs, or case law which govern it. Again, pro rata is advisable, but it's not required. And lastly, contributory negligence, comparative fault. Kansas does follow the modified comparative fault rule. It's one of 11 states which follow the 50% bar rule, which is better than pure contrib, but not quite as good as the 51% bar rule. So I do apologize for both the paucity of substance in the PowerPoint. There's just no way. I mean, this to include everything in there without being unfair. I couldn't say one thing about MedPay without saying everything about MedPay in any one state. But we do have a chart on our website that you can print off, which contains a bare bones skeletal summary of MedPay PIP in all 50 states, including the 10 that we've gone over. Same thing is true for workers' compensation subrogation. There's a chart for all 50 states which covers the main statute, our subrogation rights. Can we intervene? Can we recover against MedPay, legal mal, the allocation formulas, whether employer contribution is allowed, whether negligence reduces the recovery, et cetera, the credit. So you can print those off, and those can be of use to you. But by far the best source will be the books, as they contain all of the detail that is needed, and which are in every law school in the country. So the young law students are learning about it, but the trial lawyers out there probably are not. I thank you for attending. I will, Jamie has indicated that we will answer any questions you might have. Just go ahead and email those to Jamie or myself, and I'll be happy to answer those. I thank you for attending. We certainly look forward to the prospect of handling some additional subrogation work for Triangle. Right as of now, we don't have a whole lot, and hopefully we can improve that, because I'm confident that we can help Triangle help its insureds keep their premiums low by successfully subrogating and maximizing their subrogation recoveries in years to come. Thanks a lot for attending. I hope it was informative, and I hope you understand the nature in which I sort of cautioned that we did have to cover a ton of material. Like I said, Texas Work Comp Subro alone is 4 hours, the seminar that we have on that. So, well, God bless. Have a great day, and we'll talk to you soon. Bye-bye.